Hello, everyone. Welcome to NCSL's webinar, 2019 Trends in Occupational Licensing. My name is Suzanne Holteen, and I will be introducing this webinar today. I am a program director with the National Conference of State Legislatures. My colleague, Zach Herman, will be moderating the webinar and will introduce himself shortly. Today's webinar is a platform for information exchange and engagement. Over the next 60 minutes, we encourage participation through our chat box, so feel free to type your questions and answer any questions in the chat box, which is in the lower left hand of your screen. To begin building some comfortability with the chat function and to also learn who is on the line today, I invite you to type in the state from which you are calling now. I want to briefly mention the resources. Above the presentation, you will see a couple tabs with one of them labeled Resources. Here you can find and download a PDF version of the PowerPoint. Another tab is labeled Speaker, where you can read the bio of today's speakers. You can access these tabs at any time during the presentation. Today's webinar is being recorded and will be available on NCSL's website within the week. And now I'm going to hand it over to my colleague, Zach.
Hello, everyone. My name is Zach Herman. I'm a policy associate with the Employment, Labor, and Retirement Program here at NCSL. I wanted to start out by giving a brief overview of what we're going to cover on today's webinar. So first, we're going to talk about the occupational licensing project that we are working on here at NCSL. Then we're going to have highlights from two of the states that we've been working with pretty closely on occupational licensing, Idaho and Vermont. Then we'll move into the actual trends, covering 2019 trends, and also a little bit of a preview of 2020, and then close with a review of our databases and resources and publications. We have three speakers today, including myself. We also have Chris Winters, who is the Deputy Secretary of State for Vermont, and Senator Todd Lakey from Idaho. So an overview of our project. This work is a partnership between the Council of State Governments Center for Innovation, the National Governors Association Center for Best Practices, and the NCSL Employment, Labor, and Retirement Program. It started with an initial grant from the Department of Labor in 2017. We received additional funding for this work in 2018. The project has two very broad goals. The first goal is to work with states to identify ways that they can reduce barriers to the labor market. And so that's with states identifying which occupations they specifically want to reduce barriers to the labor market with. And then we also work with states to help improve portability of licenses across state lines. All of this work is based on states' priorities, so we don't push any particular policy or piece of legislation or ideology with licensing. We instead help those states figure out what's important for them and then work from there. We also focus all of our research around 4 key populations that are disproportionately affected by licensing. These populations are military families, individuals with criminal records, immigrants with work authorization, and dislocated workers. We achieve the goals of this project through a 2-pronged approach. The first prong is our Occupational Licensing Learning Consortium. The states that you see on this map in yellowish-orange were the original 11 states that we started with in 2017-2018. And then in 2018 proper, we added 5 more states to the consortium, so we have 16 states now total. The consortium states receive a variety of services, including specialized action planning and in-state meetings, focused research for their state on occupational licensing, and then they had access to invite-only meetings where we brought experts on occupational licensing to the meeting, and they could get on the cutting edge of licensing policy. The second prong of this project is our research and publications, which we'll talk about at the end of the webinar. So moving right along, I want to introduce Senator Todd Lakey from Idaho, who is going to discuss what Idaho has done in 2019 related to licensing and what they're looking to do in 2020.
Well, thank you, Zach and Suzanne. Appreciate the opportunity to present today. We started, as a result of our participation in the consortium last year, we created a new chapter in our code called the Occupational Licensing Reform Act, with the idea that we would be plugging pieces and parts into it over time. Last year, in 2019, we passed legislation regarding veterans and spouses. That was our first component. It required that licensing authorities accept relevant and applicable military training and education and service and experience, and also provided for an expedited application and processing of licenses by the licensing authorities. And then we adopted, I think from what I've seen, the broadest definition of military that we could, or that as I said, that I've seen. It includes members of the military, whether they're active, guard, or reserves, former members of the military, which was something I don't know if we've seen before, and then anybody that's classified as a veteran, which again would be most of those, and then the spouse of any of those designations. It provides for licensure of these individuals if they have a license or certificate or qualification in another state and or another territory or district if they're in good standing. It also provides for a licensure by endorsement process, and allows, if we already have a compact in place, to utilize that process instead. And then this year we've got 4 pieces that we're looking at. The legislation's drafted. We'll be putting it forward. The first is our Sunrise component, and we're taking. We heard different approaches as we were looking into this. The approach we're taking is to establish a licensing review committee, and that would be comprised of legislators, 4 from the House, 4 from the Senate, appointed by leadership, and we're looking at a 3-year trial basis for this. We did get a little bit of pushback from some because of the way we're approaching it. The committee would make a recommendation, but it would be required for anybody that's proposing new licensure to go through this committee process before they can bring legislation. And some legislators were of the opinion, well, why can't they still just come to us and run their legislation? So that's kind of our thinking for the 3-year trial. But what they have to do, they have to submit an application to our Legislative Services Office by May 1st. And there's some other timelines to meet. So the review is done by the time we start the session in January. And then in their application, they have to identify their relationship to the profession or occupation, why it's necessary, their proposed licensure or registration or whatever their regulatory process they're proposing, how it's necessary to protect against present and recognizable harm to health, safety, and welfare, why their proposal is the least restrictive regulation to protect from that harm, why the public can't be protected in another means. Also, they have to describe kind of a cost-benefit analysis, why any cost would be outweighed by the benefit they're proposing, and then whether there is any unreasonably negative effect on job creation, job retention, wages, and the ability to work in that occupation, and then any other relevant information. After they submit that application, our Legislative Services Office will prepare an analysis and a report to the committee. We felt like it was important that our legislative staff not make a recommendation. We didn't want somebody pressuring them to get something out of them, but we wanted it to be factual and neutral. And then the committee would review that and make a recommendation based on those criteria. And the committee's recommendation would be sent to House and Senate leadership and then forwarded ultimately to the germane committee that would hear the proposed legislation. The second portion we're adding is universal licensure, and it's establishing a procedure for issuing licenses to anyone that possesses a current or valid unrestricted license in another state and demonstrates competency. We also provide for the ability to grant a limited license. If the scope of practice is narrow in another state, they can get a limited license here while they're working on their full licensure. The other section we're including is an opportunity for someone that has a criminal conviction to make an inquiry about the potential impact of that criminal conviction on their ability to get a license, and get an advance analysis, but it's very much dependent on the information they provide being accurate, and then no change in circumstance between the time they make that request and when they actually put it forward. And then the last one is criminal relevancy in regards to licensing. We state that the license cannot be denied on the basis of a prior criminal conviction unless it's relevant. And then we provide relevancy criteria. Have to look at the nature of the offense, the seriousness of the offense, the relation of the crime to the ability and fitness to perform in the occupation, how long ago was it, the evidence of rehabilitation and treatment and good behavior since then, and then any other relevant factors. And then we're also going through our code and taking out all the old crime of moral turpitude or moral character language and requiring that they do that relevancy analysis. So those are the things we're working on in Idaho.
Thank you, Senator Lakey. We do have one question that we were hoping we could ask you. We see that you have a lot on your 2020 agenda. Do you expect any pushback on what you're trying to accomplish, or do you think it will be an easy sell for your colleagues?
I think for the most part, it will be easy. We went through an interim committee process that Representative DeMordaunt and I co-chaired, and so we heard from a lot of the stakeholders going in. Some were concerned about limited licensure and how they would administer that, but we made it discretionary and provided that it was a license that could be granted until they got their full license. We made a couple of other adjustments for stakeholders. So I think we kind of vetted that part pretty well. Where I see the potential challenge coming would be from my fellow legislators that don't really want to make the committee process a requirement. Still let somebody go straight to their legislator to pursue additional licensing. And the committee, it was a large majority vote, but it wasn't unanimous to make the committee a mandatory requirement, just as essentially an extra vetting or maybe hurdle, for lack of a better term, before somebody is proposing additional licensing. And we thought it was important to make it mandatory. Otherwise, if folks recognized it was another step to go through, they would simply skip the step and go straight to their legislator.
Thank you, Senator Lakey. Next, we're going to move to our next presenter, Deputy Secretary of State for Vermont, Chris Winters. He's going to talk about what Vermont has done in 2019 and what they hope to do in 2020.
All right, thank you, Zach, and I really appreciate the opportunity from NCSL to speak to some of these issues. That's the value of NCSL. It's been great. We've been able to, through this licensing consortium, talk to a lot of different states and share ideas and best practices. And some of the best ideas that we get, we steal them from other states. So I hope in my presentation today there are some ideas out there that the folks participating in this webinar will think are good ones, and we really encourage you to reach out to us in Vermont or through NCSL to hear more about them. Some of the things that we're doing in Vermont that we did do in 2019 and we are planning to do in 2020, you'll hear some of the same ideas that the senator from Idaho just presented. Like I said, there's a lot of great conversations going on through the consortium that have led to these ideas. In 2019, we were able to pass a uniform process for foreign credentialing. And I just realized that I didn't put any of the bill numbers in here, so I'll say them. That was House Bill 427, which is now Act 10. And it gave our Director of Professional Regulation the flexibility to develop a policy for evaluating foreign credentials for immigrants and new Americans. It allows the director to use a third-party credentialing service, but it just gave us some of that flexibility to account for the various kinds of applications we were seeing come through the office that may come from highly qualified individuals from other countries, but didn't quite match up with what we have for Vermont requirements for those credentials. So that's given us a flexible pathway to deal with some of those, and hopefully to make Vermont attractive to immigrants and new Americans and folks with credentials from other countries. We also put into play a uniform process for returning to practice. Vermont is what we call an umbrella agency state, where we have 50 different professions under the Office of Professional Regulation in the Secretary of State's office. So these things that we passed, we're able to put them in one spot in the law, and it applies to 50 different professions immediately. This allowed us to have a standard for coming back after an extended absence from practice. So it gives our Director of Professional Regulation the flexibility to say this is the standard that we accept for someone coming back after an absence. And then every once in a while, we'd see some very unusual circumstances that didn't quite fit into the law for letting them come back to practice, even though it was very apparent that they're highly qualified and safe to practice. They didn't quite fit into the reinstatement or renewal process. So again, this gives us a little bit of flexibility in letting those folks through in unusual circumstances. A third thing that we accomplished within our annual Office of Professional Regulation bill was to convert from one model of regulation to another. The traditional model in Vermont and in most states, I think, is the board model, made up of appointees, typically of the governor's office, appointees from the professions themselves. And there have been some antitrust concerns that have popped up over the years as the self-regulated professionals, perhaps in rare instances, but it does happen, they attempt to kind of protect their profession and control the marketplace. We've always been advocates of the advisor model of regulation, which appoints 2 to 4 members of the profession to advise the Director of Professional Regulation in all matters related to the profession. So we think it's a more efficient, less unwieldy. We can move a lot faster. It's a more nimble form of regulation. And so we had 2 of our boards, the Radiologic Technology Board and the Board of Real Estate Appraisers, convert from the board model to the advisor model. And that was favored by the boards themselves and with the support of the board themselves. So we're pretty excited about that. And you'll see in the next slide, in 2020, we have one more board moving in that direction to become an appraiser model versus a board model of regulation. One other piece from our annual OPR bill, which was House Bill 104 from last year, Act 30, was a report on licensing efficiency. So it required us to look across the state of Vermont at different licensing agencies. Although we have 50 professions, there are another probably 30 or so professions and occupations and licenses that reside outside the Secretary of State's office. This report required us to do kind of a survey of what's happening out there in the state of Vermont and seeing if there are any efficiencies to be gained by bringing those licenses under one roof to reduce costs, to increase public protection, to share resources, to share best practices, and to have a situation where if you have a great public policy, like the uniform process for foreign credentialing, you can put it in one place and have that apply to all of the licensing in the state of Vermont and not have to go into each section of statute or go before each independently authorized board to see if they'll come along on the policy. You can do it kind of in one fell swoop. As for 2020 proposals, our legislative session just started up again 2 weeks ago, so they've been in session for 2 weeks now. Here's what we have proposed. This is in conjunction with our governor's office, our governor's administration, is a uniform licensing law, and a lot of these ideas came from the NCSL consortium and being able to carve out the time to figure out what direction we wanted to go in as a state with respect to licensing. we have, similar to what the senator from Idaho just described, fast-track endorsement process in this proposed bill. And let me just give you the number of the bill. It's Senate Bill 233 is this uniform licensing law. It would, as the senator described, for anyone who's licensed and in good standing in another state for the last 3 years, would put them on a fast track to come into the state and get their license. We think this is a workforce development bill. We think it's an economic development bill. And we have our governor's office and our legislature standing behind it, along with the Secretary of State. That's just one piece of it. We also have a second chance proposal in there, again, as described by Idaho, very similar. It's a pre-application process. So if someone has a criminal history, a criminal background, and they're thinking about applying for a license, perhaps they're thinking about investing in an education or training in order to get that license, they can come to us first and find out if that would somehow be a bar to getting the license, depending on their criminal history. So this gives them that opportunity to come to us, ask us how we would handle an application for licensure with such a criminal conviction, and they can get that answer ahead of time before they go ahead and invest in education or training. It also gives some military credentialing equivalency power for our director. What that means is our director of professional regulation can take a look at experience from the military. Let's say one example that we have is the medic to LPN pathway. So someone who's been a medic in the military can use that experience if we come up with a process and do the evaluation and say that's equivalent to an LPN license in the state of Vermont. Once we've set that pathway, it makes it very easy for medics to become LPNs in the state of Vermont. We can do that with other areas of military experience and other credentials that we provide. So that's the military credentialing power. We've also placed in this bill military and spouse fee waiver authority. So the director can waive fees for licensure for members of the military, veterans, and their spouses. The other thing that that I should mention is that this goes across all licensing agencies, not just those in the Office of Professional Regulation. So this is kind of a big deal that we're applying policy across all of these. And so that would include not only the 50 professions that we regulate, but teachers, plumbers, electricians, medical doctors, and some others that are in other areas regulated by other agencies in the state of Vermont. We'll be coming back with that umbrella agency report that I mentioned that passed in our annual bill last year. We've been talking to the various state agencies about how they do licensing and whether we could work together to share resources such as our technology, our licensing systems, our disciplinary systems, our due process procedures, so that we're not reinventing the wheel or treating licensees or consumers or complainants different depending on which area of the state that they're looking at. So we're hopefully going to move forward with some recommendations to consolidate licensing, more of licensing under one roof. We did do a nurse licensure compact survey and report last year and found that the majority of nurses in Vermont do support joining the nurse licensure compact. So that a compact is an agreement among states that lets you travel freely among those states when you have a license in one of those states. Vermont is not a member of the compact yet, but we are recommending that Vermont should join. There are a couple of pending bills that would do that, Senate Bill 125 and House Bill 425, and we do expect our legislature to pass the law that allows us to join the compact this year. We had another report. We had a lot of reports due last year. Unfortunately, they're great reports, but we had a lot of them to deal with. Another was the Canada Bridge to Licensure report. Vermont does border Canada, so we were hoping to attract more Canadian licensees into the state. Again, like foreign credentialing, the foreign credentialing discussion there, requirements don't always match up. We had the authority for the Office of Professional Regulation to have that flexible process. But all these other state agencies that I mentioned Agency of Education for teachers, the Department of Health for medical doctors, our Department of Public Safety for plumbers and electricians don't have that same pathway and weren't affected by that law that passed last year. So what the legislature asked was, can you take a look into both Canadian bridge to licensure and apprenticeships across all those other state agencies that do licensing and make us some recommendations? So we're recommending that they put in place similar steps that we did last year for our Office of Professional Regulation, except across these other state agencies, both to facilitate our neighbors to the north coming to work in Vermont, we hope, and also to make different pathways into licensure that aren't always just formal education, but also apprenticeships. So we have a report those reports all were due on January 15th, and those are available on our legislature's website. If you search reports, you'll see the ones that were recently out. And so we have those several reports on occupational and professional licensing in Vermont. So that's what's going on in the state of Vermont. We're tackling a whole bunch of stuff. We're not exactly sure what will pass this year, but we're hopeful and optimistic that the conversation around occupational and professional licensing has really changed. It's really shifted over the last few years to understand that there is an economic impact, there is a social justice impact to continually increasing barriers to licensure. And so we hope we're doing some good work to reduce the unnecessary barriers while still protecting the public. Thanks again, Zach and Suzanne, for the opportunity today.
Thank you, Deputy Secretary Winters. We have a couple of questions for you. First off, it's a two-part question on advisor model. So first, could you give the number again for the advisor model bills for radiologic technologists and real estate appraisers? And then also explain the difference between a board-based model and an advisor model.
Sure thing. So that was House Bill 104, and that was from 2019. It was effective July 1st of 2019. And as enacted into law, it would be Act 30. And the differences is, so the board model is what most states have and what most people think of when they think of a professional regulation. It's that bunch of members of the profession, and usually a couple of public members as well, appointed to govern the regulation of the profession. So they're appointed by the governor's office. They're typically fairly independent. They typically have some connection with the governor, and so in some states more than others, it's a political appointment. And what they do is decide, what the rules are for the profession, what the requirements are for licensure, what the standards are. And that's your typical board model. And also on the disciplinary side, they have the power to approve and reject applications. They have the power to conduct disciplinary hearings and sanction and remove licenses. And so that's the typical model of regulation. An advisor model is there's less power invested in the professional members. They are advisors to the administrative agency. So in the case of Vermont, we have somewhere between 2 and 4 advisors appointed for the typical profession. So in the case of radiologic technology, for example, we would probably have 2 radiologic technologists, 1 radiologist appointed to advise our director of professional regulation. These appointments are made by the Secretary of State and not by the governor. And the other, you don't see a lot of difference in regulation, but we think it's more flexible and more nimble because our director can just pick up the phone at any time if there's a question or any of our staff have a question. They pick up the phone, they talk to the advisors, they hold impromptu meetings. They don't have their formal, once a month meetings where you have to gather a whole bunch of people and have a whole lot of process. And it allows us to be more responsive, I think, to changes in the profession, to individual application decisions. And then when there is a disciplinary issue, we have an administrative law officer, a legally trained person who hears those cases, and those advisors actually act as experts. So, of course, we don't know everything about radiologic technology, so we need those people with expertise in the field to advise us on what the rules should be, what the standards for licensure should be, whether or not something is unprofessional conduct or a violation of the standards of the profession. So they do sit, we rely on them just like we would rely on a board, but the ultimate decision-making authority is in the hands of the director of professional regulation and not in the hands of the boards themselves. And that's kind of a big deal considering the antitrust problems that we've been having since the North Carolina dental decision that says the state has to actively supervise professional regulation so that we avoid those antitrust issues of trying to control the marketplace.
Thank you, Deputy Secretary Winters. We have one last question for you. Does the Second Chance Amendment apply to medical doctors and other health-related professions like nurses?
It does. In Vermont, nurses are in the Office of Professional Regulation in our shop here at the Secretary of State's office, but medical doctors are in the Department of Health. But the great thing about this Uniform Licensing Law Bill S-233 is that it applies across all of the different agencies in the state. So it does sweep in those professions in the Department of Health, including medical doctors.
Thank you, Deputy Secretary. We're going to move on to our 2019 trends in occupational licensing. So as a broad overview, we saw well over 1,000 pieces of legislation introduced in 2019, 1,229, and then we saw almost 450 pieces of legislation enacted. So it was quite a large year for occupational licensing in 2019. We also saw that all 50 states introduced at least one piece of legislation related to occupational licensing. On the right, we have a heat map of the number of bills introduced by state. So the darker the color, the more bills that state introduced. You can see that Texas, California, Arkansas, Illinois, Massachusetts, and New Jersey all introduced well over 60 pieces of legislation in 2019 alone. Breaking down that large bulk of legislation, the majority of those bills were related to oversight for occupational licensing. So oversight can include things like the board composition and the number of members in that board, what qualifies them to be a board member, what's the application process. Some of them can be enforcement powers for the board, so does the board have rulemaking authority? What's the extent of their rulemaking authority? Then there's a couple of pieces of legislation that are specifically limiting board powers, whether it's bills like we saw in Vermont that are switching them over to an advisory model, or like West Virginia HB 2204, which prohibited boards from hiring lobbyists. And then finally, we've seen a lot of legislation that is more directly outlining in statute how government and legislative bodies supervise these boards actively to comply with the incidental ruling. Out of the oversight legislation, board legislation was the bulk of it. So we had almost 400 pieces of oversight legislation introduced with 155 enacted. Of those oversight legislation, 225 are related to boards, and 208 of those pieces of board legislation were enacted. So boards got a lot of attention in 2019. Then we also saw requirements for licensing also got a lot of attention. Education requirements saw 125 bills introduced with 52 bills enacted. And so this counts for both the continuing education requirements for renewal of licensure and the base education requirements to get your initial license. Fees saw 120 pieces of legislation introduced and 48 of them were enacted. Looking at education legislation, we saw specifications for the type and division of continuing education hours. So this means that if you have 15 continuing education hours required over 2 years to get your license, the board or the legislation may be saying 5 of those hours have to relate to changes in administrative rules or changes in how you apply this certain practice. We also saw changes in the type of supervision required for qualifying hours of experience. This can be expanding the types of licensees who can qualify as supervisors for your experience hours. So an example would be social workers working in a clinical setting, allowing their experience hours to be supervised by a licensed professional counselor or a psychologist, not just a licensed clinical social worker. We also saw expanding requirements to allow the inclusion of experience gained in an apprenticeship program. And then Utah HB 226 allowed for competency-based assessments, which is a sort of newer way of assessing that you have the skills necessary to perform the functions under your license. And then we also saw more movement on the prohibiting of revoking licenses based on student loan default, all in requirements. For fees, we saw lots of changes in fees generally. Some were reductions, some weren't necessarily direct increases, but maybe raising the ceiling. We saw Texas enact fee changes for real estate licensure, and then both Nebraska with their bill 112, and West Virginia with Senate Bill 396. Both lowered or established fee waivers for low-income individuals and dislocated workers for fee-related legislation. So we also track legislation related to our 4 key populations in our project. Looking into the legislation related to those populations, ex-offenders got the most legislation, with 94 bills introduced and 43 enacted. These pieces of legislation all hit similar points. These points were allowing for predetermination in the application, so the applicant can apply to the board and ask for a determination as to whether or not their criminal record would be disqualifying all other standards being met if their criminal record would be disqualifying from receiving a license. We also saw a lot of removing vague terminology like good moral character and moral turpitude from legislation, or from statute, and then another group of pieces of legislation were looking at specifying what types of criminal convictions would be disqualifying for certain licenses. An example of this would be not allowing people who are convicted of financial crimes to get their license as an accountant. And most states that are introducing ex-offender legislation are looking at aligning criminal convictions with the occupation itself or the license itself or the scope of work of the license. Then the next population that we saw get a lot of attention in 2019 were veterans and military families. 52 bills were introduced and 26 were enacted. These also fell along some similar patterns in the type of legislation that was being introduced. Fee waivers was fairly common for military families. We saw this again with Nebraska LB 112 and Oklahoma SB 670. We saw an increase in expedited licensure. This means once a military family has moved into the state, they can then apply for that license, and their application would be expedited, usually anywhere between 6 months to a year faster than normal. We saw overall process improvements with education and crosswalking experience gained while in service. An example of that is Nevada's AB 25. And then we saw exemptions for military spouses for licensure requirements under certain circumstances. An example would be South Dakota's HB 1111. These exemptions usually require that the person applying already has a license from another state that's in good standing with that state. Then the next big trend we saw was licensure mobility. We saw 125 bills introduced in 2019, with 52 of those mobility bills enacted. That covers mobility broadly, so this could be expanding reciprocity for certain occupations. This could be introducing compact legislation, or it could cover things like allowing exemptions for military spouses. The mobility category is fairly broad. Then within that mobility category, we saw 25 bills related to interstate compacts introduced and 3 of those bills enacted. You can also see on the right that there's a map from our colleagues at the Council for State Governments. They published a report called Promising Practices in Licensure Mobility, where they looked at what states are members of, how many states are members of certain numbers of compacts. So how many states are members of the 6 occupational licensing compacts, or 5, or so on. We also saw the introduction of the enactment of the telepsychology compact called SIPACT. Georgia was the 8th and final state necessary to adopt this telepsychology compact in 2019. The other big sort of trend in 2019 that we saw with mobility was the rise of what's been called universal recognition bills. This started with Arizona HB 2569, and then we also saw Pennsylvania bill, House Bill 1172. Both of these were enacted, and what they did was allow for people from other states who come in and establish residency in Arizona or in Pennsylvania can have a faster, simpler process for getting their license. It was billed as universal recognition, but it's sort of a misnomer. So the new applicants have to establish residency in either of those states. They also have to pay all applicable fees. They cannot have a disqualifying criminal history, and there's still a lot of cannot have committed an act that requires is disqualifying or requires disciplinary action. So that doesn't mean that someone from Wisconsin can go to Arizona and practice without applying for a license. Another important thing that we wanted to talk about with these universal recognition bills is that they're not reciprocity bills. So reciprocity specifically establishes an agreement of recognition between 2 states, and these bills are not establishing agreements of recognition with other states. So someone from Arizona can't go to another state and meet all of these same requirements and then practice in that other state. Then finally, we've seen an emerging trend with connecting licensing requirements to workforce development, specifically making apprenticeship pipelines for certain occupations a little bit smoother if that apprenticeship pathway ends in a license to practice. So we've seen that with Idaho SB 1053 and Iowa SB 1255. Those were both specifically for barbers and cosmetologists participating in apprenticeship programs. Vermont HB 104 relates to the establishment of apprenticeship pathways for licensure, those through accountants, dentists, nurses, optometrists, and therapeutic pharmaceutical agents. And then Florida aligned their licensure requirements and their healthcare apprenticeships a little bit more with SB 924. Moving into 2020, all of this can change. Not every state is in session yet, so this is all very preliminary, but we're already tracking 509 bills either introduced or pre-filed, so it looks like 2020 will be another big volume year for licensing legislation. We've seen some very early trends in that legislation, with a lot of it relating to healthcare profession. Both healthcare professions that require a master's degree or more and healthcare professions that require a bachelor's degree or less. We've seen some movement on education reciprocity licensing and mobility of teachers' licenses. Trades and real estate licensing is receiving a lot of attention, both for requirements and supervision. And then finally, we've seen an increasing amount of states interested in the sort of licensure recognition bills, universal licensure recognition bills. Virginia introduced a bill recently to establish a broad licensure recognition, and Ohio also recently introduced a piece of legislation related to licensure recognition. Then Finally, we'd like to talk about the resources we offer under this project. So we have our occupational database. This database currently sits at 34 occupations that require less than a bachelor's degree. And we cover how many states license them and then what are their broad requirements across education, experience, disqualifying criminal history, cost of initial licensure, and things like that. This database will be updated to 48 occupations this month. We're in the process of getting that uploaded right now. That will expand the database to include occupations that require a bachelor's degree or less and have a projected growth rate of above 0 for the next 10 years. Along with that database update, we will also be publishing, in partnership with the Council of State Governments, a paper on mobility and reciprocity for teacher licensure and a policy paper on child care worker licensure. Then on the right, we have our legislative database. So this is where we store all of our legislative tracking. We have our tracking from 2017, 2018, and 2019 listed in this database, and you can sort it by state and by tracking category. It is important to note that 2017 is only enacted legislation, whereas 2018 and 2019 includes all introduced legislation and enacted legislation. Then finally, I wanted to highlight our recent publications. So last year, we published the Evolving State of Occupational Licensing report. This is an updated literature review of occupational licensing-related scholarly articles and publications. We have our Barriers to Work series, which are our little reports on population-specific policies and how our 4 populations are affected by licensing regimes. And then the Council of State Governments, CSG, published 2 reports recently. The first one is Promising Practices on Licensure Mobility, and then the second one, which they just released, is Promising Practices on Occupational Licensing Requirements and Portability Options. Then all of the partners, NGA, CSG, and NCSL, also publish regular blogs and trackers and policy papers on occupational licensing as sort of hot topics come up. And we encourage you to visit all of these publications and databases as you sort of work on what you want to do in 2020. And then now we have time for questions. If you have questions, if you could type them in the chat.
Great, and while we're waiting for a couple of our audience members to hopefully type in a few questions, Zach, I was just wondering, could you kind of elaborate on what opportunities we have for states who aren't involved in our consortium? You kind of touched on the research, but how else can states get involved with NCSL in this work?
Yes, so we offer to any state, not just our consortium states. We can provide expert testimony at committee hearings. We can't endorse a particular piece of legislation, but we can provide sort of examples of what other states are doing on a particular issue. We also can provide technical assistance in the form of coming and presenting to lawmakers or to administrators on a specific topic. And then we can also come and do technical assistance with action planning. If you have a subcommittee or a group that wants to do a specific thing, we can come in and help develop a plan for how they want to execute it.
Great, and while we continue to wait for hopefully a few questions from our audience, you talked a lot about the general recognition legislation. Arizona and Pennsylvania both passed in 2019. What do you think other states do to approach recognition and reciprocity, and kind of how do other states look at both recognizing licenses and being involved in reciprocal agreements?
Yeah, so I think a lot of states take different paths. There's been a lot of interest in interstate compacts because interstate compacts provide a lot of sort of extra things that come with them. So interstate compacts are one of the things listed out in the incidental ruling as a way to provide greater supervision for boards, because compacts remove that direct supervision of requirements out to the compact governing association. Other states are interested in sort of state-by-state reciprocity. They may have a lot of migration between their neighboring states, and so it's less advantageous for them to join a compact than it is to build reciprocity agreements with their neighbors. And then we've seen other states like Pennsylvania and Arizona take the larger recognition process, maybe because they struggled to build individual agreements with their boards or with their legislators, and so they thought that was the best path for them to take. So it's really sort of what each state thinks is most advantageous for them to improve that mobility.
Great, thanks, Zach. And it looks like we have a question from an audience member joining us from Georgia, who says that Georgia has a problem adopting the interstate medical licensure compact, with the FBI having a problem with the background check language kind of related to the IMLC. Do we have any other states on the line who have run into problems with FBI background checks and joining compacts? If anyone has any thoughts on that or any experiences, feel free to enter them in the chat box.
And then we are happy to connect you with one of our experts at CSG, our colleagues at CSG, who do a lot of our mobility and interstate compact work as well. And then we have one final question that is looking at, asking us to describe in more detail what predetermination for criminal background checks looks like. So for that one, it's important to know that predetermination is not having someone apply and then guaranteeing that they will get that license if their criminal record is not disqualifying. So it's the applicant thinking about picking a certain pathway that ends in licensure. They can apply to the board and say, hey, if I complete all of these other requirements, will I then be disqualified because of my criminal record? And the board can then let them know yay or nay whether or not that record will be disqualifying. So the predetermination is not a pre-application. It's a determination to see if the record is disqualifying. So we have another question asking about legislation from 2018 to 2019, which was actually enacted which improved the ability of formerly incarcerated people to obtain occupational licenses. I can send you bill numbers specifically. I think moving back up to the slides. So all of the bill numbers that I have listed on the slides were enacted in 2019. And so the recording will show that, and then I can send more at the end of this as well.
It looks like that might be all the questions that we have from our audience. Do we want to go ahead and wrap it here? Is now a good time?
I think so.
All right, great. Well, thank you everyone for joining us for our webinar today. And a copy of this will be made available on our website very shortly.